Hello, welcome to this lecture on contract formation. So in this lecture we're going to start to learn all about contract law. Now this is quite an important chapter. You can expect maybe perhaps 7 questions to be on this chapter, so pretty important. It's usually quite interesting. There's quite a lot of case law in this area, and quite often the case law makes the subject a little bit more real, a little bit more entertaining than it might otherwise be. Now, about the cases, you don't need to know the case names. You're never going to be tested on them. What's more important is that you understand the scenarios in the cases, because it's very likely that the examiner will give you a similar scenario that mirrors a decided case in your exam, and you'll have to pick out the correct outcome from that scenario. So, if we wanted to create a contract, what would we need? Well, we've set out here the various building blocks to form a contract. A contract needs offer and acceptance. It needs agreement between two parties. So one party offers to do something, somebody else agrees to do it. We also need consideration. Now, by consideration, I mean some form of payment passing from one party to the other under the contract. So if you think about your own contract of employment, perhaps you go to work, that's you providing consideration, your employer pays you, that's him providing consideration. Now, that's not all, because if those were the only 3 things we needed to create a contract, it'd be very easy to accidentally enter into a legally binding contract, and we don't really want that to happen. You know, if you're talking to your friends, or you agree with your partner that you'll empty the dishwasher, perhaps you agree with your parents that you'll give them a lift to the airport for their holiday, those are not intended to be legally binding contracts, because they lack the intention to create a contract. So we'll need to have a look at that as well. And then finally, contracts have to be entered into by people who have the capacity to do so. Now, broadly, we're talking about somebody who is of age, so over 18, and also of sound mind. And there are some rules, because certain types of contracts need to be entered into in a particular form, and we'll have a look at that as well. So, a quick definition there. What is a contract? Well, it's a legally binding agreement between 2 parties, possibly more, to be honest. It could be 2, it could be a few extras. And that agreement is evidenced, as it says there, by writing, by words, or by action. So, as we'll see in a second, we don't actually have to have our contract in writing. We just need to be able to show that there was, at some point, some agreement between the parties. Now, each one of the terms in this arrow diagram here is a bit of a term of art. Each one of these has been carefully considered by the courts, and we'll need to look at some case law to see what exactly each one of these terms means. And we'll do that in a moment. But first, I just want to introduce you to a little bit more terminology. So, first of all, void and voidable. Now, the examiner loves void and voidable contracts. He has been known to use them in lots of multiple choice situations. Now, basically, this is a way of saying whether or not a contract will be enforced. If a contract is void, then it basically means there is no legally binding contract. All those building blocks we just looked at, they don't exist. There's no contract there. The goods should be returned if they've already been supplied. Okay, so there is no contract, and there never was. A voidable contract is a little bit more tricky, because a voidable contract is actually a valid contract. But the law says that in certain circumstances, this contract can be set aside by one of the parties. Now, the thing about a voidable contract is it can only be set aside by one party. And in the notes, we've called that party the injured party. And that's because voidable contracts are normally there to protect someone who perhaps has been lied to in order to get him to enter into this contract, or perhaps who is too young to enter into contracts. So what the law says is, well, if you enter into a contract in those situations, then it's enforceable, but if that one party, that injured party, decides he doesn't want to go ahead, then he is the one who can end it, and only him. So if we have a look at some examples on the next page, we can see how that might work. So for instance, a person may lack the capacity to enter into a contract. So basically, they're not 18. Now, in that case, it's the under 18, the child, who is judged to be the injured party or the vulnerable party. And that person, and only that person, can set aside the contract. So if I give you an example, my son is 13. And if my son were to wander off down the high street and enter into a contract to buy a Xbox, then that contract would be voidable because he is not over 18, he doesn't have capacity. Now that means that if I have a very bad reaction to my son's attempt to buy an Xbox, I could march him down to the high street and insist that he sets that contract aside, that he avoids the contract. And he'd be able to do that, and the shopkeeper would have to let him. However, if we turn that around, if the shopkeeper got a better offer from someone else to buy that Xbox, he would not be able to set aside that contract. He would have to go ahead and honour the contract and sell the Xbox to my son at the agreed price. Okay, so it can only be set aside by the child. Another voidable contract would be where there is no free will, and this is where someone is pressurised into entering into a contract. Again, imagine some high-pressured salesman that won't let your granny leave the house until she's signed up to buy some new double glazing. In that case, the granny would be able to set aside the contract, again, to avoid the contract because of undue influence. Compare that to a contract which is illegal, so maybe a contract to murder someone, for instance, at an extreme. That would be void. It would never be legally enforceable. It's a contract that never was. And then finally, misrepresentation. Now, misrepresentation is something we'll see a little bit more of later. But a misrepresentation is, as it says here, an incorrect statement of fact, which you make pre-contract to persuade someone to enter into a contract. So, for instance, I might tell you that if you book this course, every single student who's ever taken this course has passed the exam. Now, that's a statement of fact, and I've made it before you have entered into the contract. Now, if you rely on that statement and go ahead and book your course, then if it turns out later that every single student hasn't passed the exam, that would be a misrepresentation. And therefore, you would be able to have this contract set aside. Again, you would be able to avoid the contract because it's voidable. But a bit like in the shopkeeper situation, I would not be able to set that contract aside because I am not the injured party. Now we have another term. This is contracts that could be what we're calling unenforceable. Now this means that strictly at law there is a contract there, but one party cannot be forced to carry it out. And the reason for that is that perhaps the contract isn't in the correct form, or possibly that we can't actually prove what the terms of the contract are. We know there is a contract there somewhere, but nobody really knows quite what was agreed. Now, the table we've got here sets out circumstances when contracts have to be made in a particular form. So let's have a look at those. Now, first of all, it's important that you note this first point here. Most contracts, in fact, probably 90% of contracts, are just oral agreements. There's no need for them to be written down. There's no need for people to sign a piece of paper. Okay. The only problem with an oral agreement is, as I was just mentioning, evidence. It can be really hard to show what the terms that were agreed were. I mean, if you just think about maybe conversations that you've had where you've perhaps agreed to do something and you and the other party have come away from a meeting thinking that you've agreed completely different things. A written contract gets around that problem, makes sure that you've got a record of the terms of the agreement. Certain contracts have to be in writing. The examiner quite likes to test you on this, and these are contracts for the transfer of land and also consumer credit agreements, anything governed by the Consumer Credit Act. Okay, so they must be in writing. So you must have a piece of paper setting out the terms signed by the parties. Other contracts must be what we call evidenced in writing. Now this is an interesting one. You don't actually have a piece of paper setting out all the terms signed by both parties, but what you have is a written record of the agreement. So perhaps minutes of a meeting, perhaps somebody subsequently writes to the other party setting out the terms of their agreement, but it's not actually signed by both parties. And the one that you need to know there that needs to be evidenced in writing is a guarantee. Now, email exchanges are increasingly common as a way of setting up a contract, and there has recently been a case that's gone to the Court of Appeal. Now, this is important because it's a pretty key case in the courts, and a senior court at that, accepting email exchanges as a basis for contracts. And what they said was they recognise now that there often isn't one single document recording the contract, but so long as there was an exchange of documents and the terms of the contract could be clearly identified, then the typed name of the party could be accepted, in effect, as a signature to the terms of the contract, and therefore we had an enforceable contract. Now, we just mentioned there the Common European Sales Law. This is a new regulation that the EC have been trying to introduce in order to try and improve trade between member states, and it's basically a harmonised contract law that governs all contracts. Now, the UK government have been opposing this, so we'll have to wait and see how much it will come into force within the UK. However, in any case, it will only apply where the parties choose to adopt it. So if they have a term in their agreement that says we're governed by the CESL, then the terms of the CESL will apply to that contract. Beyond unawareness, you won't be tested on that. Finally, though, standard terms. Now, we all deal with standard terms every day. You enter into a contract with someone and you flip it over and there's a big section on the back called Terms and Conditions. I know there's one on the First Intuition booking form, and if you look around you, you'll see that there are terms and conditions on every single agreement that you enter into. Most commonly now, of course, it's an internet website with a little box that says, tick the box to say you have read and understand the terms and conditions. Now, if you don't get to negotiate those terms, then they are standard terms. Now, the problem is that quite often both parties will automatically reel out their contract on their standard terms, which are usually different. So in those circumstances, it might not be clear which terms are actually intended to apply, which person's standard terms will govern this contract. So what the courts have said here is that if that's the case, if there's no clear agreement, then neither set of standard terms will apply, and instead we'll resort back to general contract law provisions. So if you try and get too clever, you try and adopt too onerous terms, it's quite likely that you will sort of fall over yourself in that, and you'll have to fall back on basic contract law. Okay, I'm just going to leave that introduction to contract law where it is, and then in the next lecture we'll come back and start to look at the rest of those building blocks that we mentioned at the start.